Whenever something goes wrong, our first instinct is to ask, okay, who's to blame here? But in the legal world, it's almost never that straightforward. Today, we're going to dive into some really interesting legal defenses that can totally flip the script on who's actually responsible.
All right, let's paint a picture. You're walking through a store, you slip on a wet floor, and you fall. Seems like an open and shut case, right? I mean, obviously it's the store's fault, right? But what if you were totally glued to your phone? Texting a friend, not looking where you were going. All of a sudden, that simple question of who's to blame gets a lot more complicated.
And that little wrinkle brings us to our first big legal defense. It's all about this idea of shared fault. You can think of it as the, hey, hold on, it wasn't just my fault defense. The fancy legal term for it, contributory negligence.
So, what does contributory negligence actually mean? Well, it's pretty much what it sounds like. It's when a court looks at a situation and says, yeah, the defendant was at fault, but the injured person, that's the plaintiff, was also being a little careless. So they share some of the blame for what happened. The damage, as one source puts it, is partly due to the plaintiff's own fault.
Okay, and here's the really crucial part. This isn't an all-or-nothing kind of deal. It's what's called a partial defense. So, if the defendant can show the plaintiff was also a bit at fault, they don't just walk away scot-free. Nope. Instead, the court just reduces the amount of money they have to pay out.
Let's use some actual numbers to make this super clear. Let's say the total damages from that fall, for medical bills, time off work, all that stuff, adds up to a clean $100,000. Okay? That's our starting point.
So the court looks at all the evidence. On one hand, yep, there was a wet floor. But on the other hand, the plaintiff was completely absorbed in their phone. So after weighing everything, the court decides, you know what? The plaintiff's own carelessness makes them 25% responsible for this accident. That's their share of the blame.
And here's where the math comes in. The court takes that $100,000, lops off that 25% share of the blame, and boom, the final payout drops to $75,000. That's the real-world financial consequence of sharing the fault.
Okay, let's switch gears to our second defense, because this one comes at it from a totally different angle. We're not talking about sharing blame anymore. This one's all about whether you willingly, knowingly, took a risk from the get-go. It's called assumption of the risk.
Now, if you want to get really formal, the legal term is volente non fit injuria. It's a Latin phrase that basically means a willing person cannot be injured. But hey, let's not get bogged down in Latin, right? We're just going to call it assumption of the risk. Much easier.
And the thinking behind this is actually pretty powerful. The core idea is this: if you willingly and knowingly accept a risk, you don't get to turn around and blame someone else when things go wrong. To put it simply, you knew what you were signing up for.
And this is the absolute key difference from what we just talked about. Unlike shared fault, this is a total defense. That means if a defendant can prove the plaintiff assumed the risk, the payout isn't just reduced, it drops all the way down to zero. Nothing. Nada.
So how do you even prove something like that? Well, it really boils down to two key things. First, the defendant has to show that the injured person actually consented to the risk. Now, that consent can be express. Think signing a waiver before you go skydiving. Or it can be inferred, which means it's implied by your actions, like when you decide to join a rough game of football.
All right, so we've got these two big ideas on the table. One is all about fault, and the other is all about consent. Let's put them side by side so we can really see how different they are.
This lays it all out, nice and simple. On one side, you have shared fault. The core idea, the plaintiff was partly to blame. The result, they get less money. On the other side, you have assumed risk. The core idea here is that the plaintiff agreed to the risk, and the result of that, zero damages. It's really the difference between being a little bit careless versus giving your full consent. So, what's the big takeaway here? I think it's that the whole idea of fault is way more complicated than we usually think. It's not just about pointing a finger and saying, you caused this. It's this whole complex mix of shared responsibility, carelessness, and of course, the risks we choose to accept. And all of this leaves us with a really interesting question to chew on, doesn't it? I mean, we live in a world that's just full of risks, big and small, from just crossing the street to trying some crazy new hobby. So the question is, how do we decide, and how do the courts decide, which of those risks we've truly accepted? It's something to think about.